Number 44, People versus Derek Smith, 21105 FC.
Jessica Blanche, appearing on behalf of People.
All right.
Good afternoon, Marcia Fish on behalf of Mr. Smith.
Okay. Good afternoon.
Dr. Head.
Smith, can you hear us?
Excuse me?
Can you hear us?
Yes.
Okay, today's the date and time set for sentencing in this matter. We've gone through parts of this in the past, so I think what we're going to do to make a record is I'm going through the sentencing. Procedurally, just to be clear, there was a time at the last sentencing hearing where the prosecutor stated that she was going to be requesting a higher sentence. Both she suggested, I don't know if suggested is the right word, that she was withdrawing her sentencing agreement, but I said that I was not going to stand by the sentencing agreement either. And so we are going to proceed to date a sentence in this matter. We did have a victim impact statement last week. And so we're going to pick up, I guess, where we left off, in the sense that there are now, the prosecutor has submitted some revisions or some challenges to the guidelines that were submitted by MDOC. I have reviewed those and I have kind of gone through my own calculations again. So I'll start with you, Ms. Kracher. Do you have any challenges to the guidelines as submitted, or do you have any response to Ms. Blanche's revisions?
As far as the guidelines, I guess I'll answer this as simply as possible. Ms. Blanche did provide me with a copy of her suggested challenges. The response that I have, I don't know if the court wants to go point by point with Ms. Blanche's argument and then my argument. How would the court like us to proceed in this matter?
Well, so if you want, I mean, I've read her response and she's certainly welcome to put them on the record if she'd like. And so if you want to go point by point, I'm fine to do that. So let's start with OB4.
Ms. Blanche or I, Your Honor, I'm sorry.
Ms. Blanche, go ahead.
Judge, we're asking for OB4 to be scored at 10 points, psychological injury to the victim. Based on her impact statement, I also put supporting case law in my memo to the court. She said that it was a life-altering event. She was stabbed 30 times and has a permanent scar on her face. It has not been easy road. She has suffered from PTSD, depression, and is on psychotic medication after the incident. Based on that, I believe that it warrants 10 points score.
Rachel?
Briefly, Your Honor, I don't have any, the victim has not submitted any kind of documentation as to her depression or psychotic medication. That'd be our argument to not score that, Your Honor.
Okay. I did review the submission by the prosecutor. I'm taking into consideration Ms. Kracher's response. I obviously was present during the victim impact statement, and so I will alter OV4 to make that a 10-point score. How about OV5, Ms. Blanche?
Judge, we're asking for psychological injury to a member of victim's family, 15 points. When it comes to assault with intent to murder, you can score 15 points for victim family members. She said that the victim's son discovered the victim on the floor unconscious. He fought to try and save the victim. He is shamed for not being able to keep the scars off of his mom. He suffers from night terrors, anger, anxiety. He has had to be put on medication after the incident. He cannot fall asleep without medication. He has separation anxiety. I believe based on that, 15 points should be scored.
Okay, Ms. Kracher?
The only response I have to that is, Your Honor, is we have no supporting documentation from the child in this matter. This is strictly from the mother in this matter. Therefore, I don't think that it should be scored.
Okay. I have reviewed the prosecutor's submission. I'm taking into consideration that along with Ms. Kracher's response. My assessment in this matter is that I think because the victim relative to this, the victim's son, is a minor, I think we can take his mother's statements as supporting this, and so I'm going to score that at 15. All right, OV9, Ms. Blanche?
Judge, we're asking you to score at 10 points based on number of victims. 2 victims were involved in this matter. The defendant pled no contest to 8 women involving Crystal Lee, including assault involving her son or his son as well.
All right, Ms. Kraicher?
Your Honor, I was not at the sentencing in this matter. I looked back at the charging documentation in this matter, and the felonious assault charge was only to Miss Lee, wasn't to her son. So therefore, I don't believe it should be scored.
I'll pull up the charging document.
Yeah, I'm looking for that as well. I thought it was as well, but. Here we go.
I have it right here, Your Honor.
Count 3, though.
I'm sorry?
Count 3 is to the minor child, correct? Darren Smith?
That's what I'm just confirming, Judge, but that's what I.
Right, so counts 1 and 2 were the assault on Crystal Lee.
Correct.
Count 3 is Darren Smith, so that's the second.
Yeah, that's correct. You
Yep.
pled to counts 1 and 2.
Right.
That's
Thank
what
you,
I
Your
said on this form.
I appreciate the question, Ms. Kraicher, but I am going to score that as well, based on that as a 10. And then now on to OV10, which is an increase from 5 to 10.
Judge, that would be exploitation of vulnerable victim. There's a domestic violence relationship between the defendant and the victim. They lived together, had a child in common. Based on the supporting case, I believe that should also be scored at 10 points.
Right, Ms. Kraicher?
Well, I don't disagree that they were living together and cohabitating together, Your Honor. The issue I have is that exploitation of a vulnerable victim. Throughout this case, I'm not here to relitigate the facts of this case, but there was 2 knives found at the scene. I'm not so sure that exploitation of a vulnerable victim given 2 knives found at the crime scene represent a scoring of 10 points, Your Honor. And we don't know how the 2 knives came into play, Your Honor. So I'd ask that the OV10 that is being requested by the prosecutor not be granted.
Okay. I have had a chance to review Ms. Blanche's submission. I've listened to Ms. Kraicher's response. I will acknowledge that there has been a consistent statement from the defendant that there were 2 knives. However, the defendant pled no contest to charge, and no question that there is a domestic relationship between the defendant and both of the victims. And so I'm going to agree and increase that to a 10. So Ms. Blanche, if you want to correct my math or check my math, OV4 at 10, OV5 at 15, OV9 at 10, and OV10 at 10 makes the total OV at 110 and the OV level at 6. Is that correct?
That's correct, Your Honor.
And that would increase the guideline minimum from 171 to 270 and 285 to 450. Is that correct?
210, but let me.
Yeah, she submitted 210.
I believe it's 2, I think it's, because I believe I had the low end at 22.5 years to 37.5 years. So I believe it should be 210 to 450.
22 and a half to what?
37 and a half, that's on her submission.
210, not 270. Okay. I'm glad to have the math corrected. All right, thank you. All right, so we are now back to you, Ms. Blanche. I know that there was a victim impact statement last week. Is there any further statement from either victim in this case at this time, or are we going to take that as our statement?
No, Your Honor, that's the victim statement. She had already supplied the report.
All right, I'd like to give you an opportunity to address the proposed recommended sentence. Anything you'd like to supplement?
Judge, we've obviously been here numerous times. with Mr. Smith. Originally, we had offered a plea dismissing count 2. He was to plead to count 1 and count 3. Understanding if you were going to have a sentencing agreement of 11.5 to, I believe, 25 years. The reason for that, a lot of times for sentencing agreements, is that when the defendant takes accountability for their actions, it really speaks volumes to the victim and to us as prosecution, that someone's taking accountability for their actions. There's remorse there. But ever since the defendant has pled, he's done the absolute opposite of that. He has taken zero accountability for his actions. He wouldn't even sit in court to listen to the victim impact statement. He left during court. Has been disrespectful to this court. Every appearance he's been in, he's talked over you, Judge. And based on that, I believe that you held him to contempt last time we were here based on his actions to this court. The fact he got up and left during sentencing, the fact that he was talking over you, and based on that, and the fact that you're taking away the sentencing agreement, and he'd already, talked about misconduct and how that you could do that under the law, and we could withdraw our sentencing agreement, he should be scored under guidelines. He was given a gift of half of the guideline score. So I'm asking you to sentence him to 22 years at the low end. Thank you, Judge.
Okay. All right. Ms. Kraicher, you have an opportunity to address the sentencing. I'm saying the sentencing recommendations, the adjusted sentencing recommendation. At this time, you may allocute on behalf of your client, and then I will give him an opportunity to address me.
Okay.
Okay?
Is it okay if I stand at the table, Your Honor?
Sure.
Okay, thank you. Your Honor, say this is a case that has been frustrating, I think, it's an understatement. But before us is a bargain that was entered into between the people and Mr. Smith. And that bargain was entered into under People v. Pilgrim. On the record, this court told the defendant what the agreement was. Therefore, that agreement was put forth to him knowingly, intelligently, and therefore his due process rights at that time were not violated because he knew what he was getting into. He knew what he was doing. Okay? The court further advised the client on the November 4th hearing. I'm going to read from the preliminary exam transcript. Like, these are all the things that you have to have notice of, but I'm just telling you that, if you don't do anything wrong between now and the date of sentencing, and if your pre-sentence report is not so shocking to me, I go along with these all the time, so it's not like this is telling you, particularly Derek Smith, should be careful of this. I'm just making this announcement. Court further stated, prior to that, I had the wrong page open, that, again, he listed out some things. If the pre-sentence report isn't shocking, if you don't do something that I don't like, that's what this court told Mr. Smith. The issue with that, as far as holding him towards the misconduct, is that it's vague. Since that is vague, he should be allowed to withdraw his plea because he's not getting the benefit of the bargain that he entered into. And the court ruled that Ms. Blanche is relying on, and I'm going to read section B3, except as allowed by the trial court for good cause, the defendant is not entitled to withdraw a plea under subsection 2A or 2B if the defendant commits misconduct after the plea is accepted, but before sentencing. For purposes of this rule, misconduct is defined to include, but not limited to, absconding or failing to appear for sentencing, violating the terms and conditions on bond or terms of any sentence in your plea agreement, otherwise failing to comply with an order of the court pending sentencing. In the case law that I have reviewed relative to misconduct, the misconduct in those cases, and I'll cite them, People v. Siegel. It was published in April 16th of 2019. Ryan v. Hera, People v. Hera. People v. Jameson. we follow those cases, the common theme regarding this conduct is that there was a clear defined violation of a clear defined bond order, a clear defined order of the court. There's not here a clear defined order of the court. In other words, Mr. Smith never contacted Ms. Lee. Mr. Smith never attempted to contact his son to make him change their testimony or for leniency. What Mr. Smith did is and you'll hear from him, at our first sentencing, he appeared, and then we broke and we had a conversation and he reappeared. During the second, when we came back in session, he left, Ms. Blanche, referenced that. Well, the reason why that you'll hear from Mr. Smith, that he tells, is that he heard the court say we're adjourning this for 2 weeks, and that at that time the CO, the deputy, basically either A, let him away, or said it's time to go, or closed off the Zoom. That's why he left. Mr. Smith, by no means in his behavior.
Ms. Cratcher, I just want to be clear. You're telling me that's why he left, or that's what you're telling me he's going to say? Because you're either representing that happened and you know that.
I'm representing that's what he's going to say.
Oh.
Okay? I want to be clear about that. Okay? The issue before the court is his misconduct rises to the level that case law has put misconduct as far as objectionable action. I don't think it is. I don't think it has. Mr. Smith's conduct is out of frustration of how it is perceived to be disrespectful to this court. I've had conversations with him. He didn't mean any disrespect. He is a frustrated man looking at some serious time. Very serious time, a very serious offense that took place in front of his family. We all have bad days. We all have times where we are not in our best moments and not in our control of our impulse. Okay? But what it comes down to is, under Killebrew, he entered into a plea knowingly and voluntarily that was a sentence agreement. We would be asking that if the court is, and the court has stated, and I'm not sure if it's going to change its mind or not, that's not going to support the sentencing agreement, that this court allow the withdrawals plea in the interest of justice, and we object to any kind of sentencing that is outside the sentencing agreement that this court has been presented by the prosecutor originally. Further, Your Honor, in this plea agreement is a victim's rights case. So the victim had to have some say in the original sentencing agreement, 11 and a half to 25 years. She obviously at some point agreed to this. And that was her wish. She agreed to it. There was a reason why the reduction was so dramatic from the guidelines. And I believe that this court, in the interest of justice, and to not violate Mr. Smith's due process rights, should either file the agreement or allow him to withdraw his plea. That would be the thing to do. Because I don't believe the misconduct here raised to the level of misconduct in following case law. There's.
But Ms. Cratcher, you don't need to repeat yourself. Is that all right?
Thank you. So again, I would ask the court to file a sentencing agreement. If I may speak a little more about my client, I did have some conversations with him at the jail. I believe he is remorseful that this incident played out in front of his son. I also believe he's remorseful of his perceived behavior. And I, again, thank you for your time, and I ask the court to follow the agreement. Thank you.
Smith, this is your opportunity to say anything you'd like before I impose sentence.
Yes, can you hear me?
Yep.
Yes, I would like to say that this whole ordeal has been very stressful and uncomfortable, to say the least. And not to mention the time I'll be away from my elderly mother and my one and only sister, who's left to aid and care for my mother in her time of need. And also the children I'll be leaving behind, that I hope and pray that they become successful in life and God-fearing adults. I took a plea which was advised by poor representation. This plea prevented me from having a trial where the facts would have been laid out, which leaves allegations of the incident that were all inconsistent. So to hear every time the prosecution had a chance to describe the allegations, say that I stabbed a woman multiple times and slashed her face, is very painful and embarrassing. Not to say that I never caused her any injuries, because I did, and I take full responsibilities for the injuries that I caused her. However, the injuries to her neck, arms, back, and the slash on her face, I did not do. When my son broke the curio cabinet with her close in contact, glass shattered all over her, causing the additional injuries and the slash to her face. The three of us, and God knows this to be true. This also explains why the medical report described the injuries to her as superficial, and her discharge report said some of her injuries were scrapes and abrasions, with the most severe to her face. No life-threatening injuries. How is that? And you're being repeatedly stabbed by a 6'3" man weighing in at 386 pounds with a 10-inch butcher's knife, and not to mention you're unconscious and defenseless at the time. Yes, let's think about that. Also think about the injuries on her arm, which was described as defensive wounds. Yes, defensive wounds. How do you get defensive wounds if you're unconscious? From my understanding, you have to be active to have defensive wounds. Well, why not blame it on me? You know, I've been lied on in the past about things, and so it makes it easier for someone to do the same thing again. I come home from prison, and I choose to rekindle my relationship with Crystal because I thought the love that her and I shared was in common. But I found out that it wasn't, you know. I was just an extra body there waiting to be replaced by another man. I had nowhere to go. The place MDOC had provided for me was no longer available. So I had to stay there until, unfortunately, till things was trying to be worked out, and then the incident took place. And however, to the courts, all I did out of frustration was defend myself, and I also spoke about God. And if this is what you want to call misconduct, then go right ahead. Yes, I walked off. I came back. And when I walked off the last time, it was because I thought the proceeding was over and adjourned for the next following week, because that's the last thing I heard you say. I meant no disrespect. And every time before my feelings got involved, I would always ask you, may I address the court? I never cursed you. I never called another case. I didn't abscond. I came back to hear everything that you was willing to tell me as a man and take my full responsibility for the part I played in this. And that's all I did. You know, you told me not to catch another case, and that as long as you don't read nothing shocking in my report, that you would follow with the agreement. You know, so If you choose to do what you do, then like I said, I'm still in God's hands, and we're all in God's hands, Your Honor. You know, so if you feel in your heart that this is the right thing that you want to do, then you go ahead and do it. And may God bless you.
Okay, thank you. So there are four things the court considers when it sentences a defendant. One is punishment, one is rehabilitation, one is protection of society, one is deterrent. They have varying sort of, you know, different cases have different elements and that sort of thing. You know, you entered into a plea agreement in this matter that was, you know, less than the guidelines would have warranted. That's true. You entered into that plea agreement knowingly. We had several different hearings where you finally agreed, you had plenty of time to think about it, and you finally agreed to plead no contest to the count 1 and 3. So that carried with it some form of punishment, incarceration. Rehabilitation is out of my control. That's up to you. My concern, sir, in listening to you today, even in today where I'm going to sentence you, is that your language to me was entirely without really taking any responsibility. You say, on the one hand, a couple of times you said you've taken full responsibility, but then you go on and say you took a plea with poor representation. You actually blame your son breaking the curio cabinet for the cut on his mom's face, and then you kind of blame her. I didn't understand you. You're another body to be replaced by another man. But all of that sort of says to me that you're not really taking any responsibility for this. And that's a huge concern where rehabilitation plays in. Because I think in order for anyone to rehabilitate while they're incarcerated, they have to take responsibility and say, I did something wrong and I need to do something to make it as right as if that's possible. So I have grave concern about that. I'm going to say protection of society. This is a case where despite your 11th hour, your last minute sort of statements that this is all defensive and that this had nothing to do with you and your action, apparently today, that's kind of the first I've heard that you are saying that it's your son's fault with the breaking of the curio cabinet that she got all those cuts, and including an incredibly deep and lifelong scarring cut on her face that I've seen a photo of because it was submitted to me for part of this. So I guess I'm a little unclear about the idea that the court should not take quite seriously the idea of protecting society. And I am concerned about you. Your behavior as it's related in these hearings, I mean, I don't remember if you cursed me. I don't know, but you certainly you struggled with what we would call impulse control. You really could not control yourself during a lot of these hearings. And so it wasn't just last week where you left. It was several hearings where you were speaking over me, you were walking out of the room at the jail. And so to be clear, I don't know that I agree that that was just your mistake that the officer told you it was adjourned. The final consideration is that of deterrence. I read that as really both deterring you from future criminal action, but also this court's obligation and responsibility by its actions to deter other criminals from potentially mimicking or duplicating this behavior. So all of that is part of my consideration, sir. I am concerned about your lack of willingness to take responsibility, to blame this on your former lawyer, to blame it on your former partner, mother of your child. I don't know if you were married, but also to now today blame it on your son, who basically, I think, saved his mother's life, and that all played out in front of him. So I'm glad that you have concern about being incarcerated as it relates to your other children. I don't know that Darren really has had the benefit of that same sort of support or feelings from you, given his role in this and what he had to do. And so that's something no child should ever have to deal with. So as to count 1, assault with intent to commit murder, guideline sentencing recommendations of 210 to 450 months. It is the sentence of the court that you serve 22.5 years to 37.5 years incarceration with the Michigan Department of Corrections. Credit for 0 days served, concurrent to count 3 and consecutive to parole. Additional conditions, you must not have verbal, written, electronic, or physical contact with Crystal Lee, either directly or through another person. You must not be within 500 feet of their residence, school, or place of employment. Number 2, you must pay a $68 state cost as ordered by the court. Number 3, you must pay a crime victim assessment in the amount of $130 as ordered by the court. And number 4, you must pay court costs in the amount of $1,161 as ordered by the court. As to count 3, assault with a dangerous weapon, also known as felonious assault, there are no guideline sentencing recommendations. It is a sentence to the court that you serve 24 to 48 months incarceration in the Michigan Department of Corrections. Credit for 0 days served, concurrent to count 1 and consecutive to parole. I will strike the additional state cost as it's under the same case number, even though it's a separate count.
Your Honor, I object to this and ask to withdraw my plea.
Judge, what was the tail on that? It was 22.5 to
37.
37.5.
And just for the record, the probation officer was nice enough to put in the guideline scoring. 22.5 years is 270. So you were right. Mine was a typo of 210. So you were right, Joe. It's 270, but it is 22.5 years.
All right, so I'll correct then on the sentencing information report, it's 270 to 450, and then I've made that correction. Pre-sentence report.
Your Honor, can I speak to one of the financial aspects of the recommendation?
He's been sentenced, so, okay, that concludes the hearing, thank you.
Thank you.
22. You didn't say why, did you?
Calling number 44, People versus Derek Smith, 21105 FC.
We are back on the record. Ms. Cracher, your appearance, sorry about that.
No worries, Your Honor. Good afternoon. Marcia Cracher on behalf of Mr. Derek Smith.
All right, couple of procedural things. I'm not 100% clear whether I made a finding last week that I held the defendant in contempt. I know it was referenced, and I know you referenced it today, Ms. Blanche, so I do want to just clear that up. If I did, then I'm going to cancel that, or I will have the defendant's sentence substitute as his purging contempt of the court. I'm going to cancel any further contempt proceedings as it relates to this defendant. Further, Mr. Smith, you will be provided an appellate rights form. You, of course, know this from talking to Ms. Cracher in her pre-sentencing motions, but you are entitled to file an application for leave to appeal my decisions. The form that she's going to give you explains important rights that you have on appeal. What you need to know, though, is that if you want a court-appointed attorney to represent you on your appeal because you can't afford it, you have to request that in writing within 42 days of today's date. So today's the triggering day for that 42 days. Ms. Cracher, can you confirm that you'll get that form to your client?
Your Honor, I've already had my client sign the form. I dated it for today, and I'll be turning it in downstairs on his behalf.
Right. So I know in some of the pretrial or the pre-sentencing motions that Ms. Cracher filed on your behalf, some of those appeals, some of those motions are part of potentially an appeal. Your appeal right doesn't attach until you're sentenced, which is today. So I neglected to tell you that before I closed the hearing in the last moments, but I wanted you to just know that the 42 days starts today, as well as you have the dates that are on that form under which if you file for an appeal or you file any post-judgment motions or post-sentencing motions, that can happen. So, okay?
Thank you. Thank you, Your Honor.
Thank you. Sorry about that.